Hi, my name is Ben Cote, and I'm the owner of Cote Law Group. And today I want to cover an important topic, which is the five vital tips when preparing your will. So, why is a will important? If we get it wrong, the assets go to the wrong person or the wrong people. We can have court battles that eat up a large percentage of the estate. And probably most importantly, you lose control over the assets that you spent your entire life working to acquire. So, getting your will right is really important. So, the purpose of this webinar is to give you 5 tips to think about when preparing your will to avoid some of these pitfalls that I've seen in my practice when it comes time to actually probate a will after the person's passed away. So, who has a will? 64% of Americans think that having a will is important, but only 32% of Americans actually have a will. And the reason might be surprising. It's that most, or not most, but 40% of people think that they don't have enough assets to actually justify having a will. And that misses the point of the will. So even though you might have a modest estate, the important part is that the whatever you do have actually goes to the right people. So it's a somewhat pervasive attitude that a will is important, but it's not as obvious that people would actually take that step of actually preparing a will. And so many of my clients ask me, what's the difference between a will and a trust, and what is an estate plan? And those questions really kind of get at the heart of what the decision making process should look like. So let's start with what is a will. And so a will is simply a piece of paper which has a nomination for a personal representative, and then it names devisees. So in pop culture, we've all seen the movies where everyone gets together and a lawyer reads the will to the grieving family, and unfortunately that is largely movie magic, and by largely I mean completely. That is not something that actually happens in practice. It would be really expensive, and the will, there's really no reason for everyone to get together. And in a lot of cases, so the devisees might live across the country, they live in different states. So what we usually see is that the will would be sent to everyone, usually after a petition's been filed. So the will, it names a couple of important jobs. The first being the personal representative. We used to call them an executor or an executrix, but in essence, their job is to gather assets, pay lawful debts, and then distribute funds to the devisees. So, in the case of somebody passing away with a will, they're said to have died testate, and they will have devisees named in their will, and that's simply the people that receive the property, whether it's a bank account or stock. Those might be specific devises if it's identifying a particular piece of property or particular asset to go to somebody. And then we also have a residuary devisee or devisees. And it can be set as people, a class of people. So, for instance, your children or your descendants. So, there's a lot of variability that can come when you're preparing that will. But importantly, we also think about guardianship. So, guardianship helps us decide who are the right people or who's the right person to care for a minor child. So, if you have kids, having a will is really important because you have some say in who will actually raise your children if you were to pass away before them. And then probably the most important, and it almost goes without saying, but the distribution of assets is a key part of actually preparing the will. So what are the formalities of a will? That's an important piece to consider. So a will, we like to see it notarized with 2 disinterested witnesses. In fact, that's what the statute requires. So it's not enough to simply tell somebody about your wishes. I've had a lot of clients come in and say, well, I wrote out an outline and I left it on my desk when I went on vacation in case anything happened to me. And I think most of the people that I've talked to have understood that that isn't really legally binding, but there's a sense that maybe their family would follow their wishes, and it's better than nothing. It's also not enough to be in the process of drafting a will. I've been in situations where I've represented clients where a new will was being drafted. It was with the attorney doing the drafting, or there was a partially written will on their computer before they died, and that simply is legally meaningless unless it's signed with 2 disinterested witnesses. The court's going to ignore what's in that new draft will. So all that matters is what's included in the will. Looking ahead to the probate process. So we file a petition. So this is assuming somebody's passed away. We include various documents required by the court, including a death certificate, petition for either informal or formal probate. We have to tell the court who the devisees are. We have to tell them who's in the family with another document. We have to have a bond signed by the personal representative, basically their promise to fulfill their duties to the estate and make sure that they don't and be held liable for damages that they cause. And then also military affidavits. So there's a number of documents that get filed along with the will. Once the court is satisfied that everyone's received notice, that the will is on its face valid, and there are no objections filed, which is a big if in this case, because objections happen all the time, and it's one of the things that makes wills sometimes not the best choice for people. But the court would appoint somebody, and they would issue what's called letters of authority. So those letters of authority, you can think of them like a license that the personal representative can use to go and talk to financial institutions, and can take action at the registry of deeds by selling property. And that process of gathering the assets is called marshaling. And then once the assets are gathered or identified, the lawful debts are paid. Now, one of the downsides of a will is that it takes a year to understand what the debts of the estate are, because by statute, creditors have up to 1 year from the date of death to actually file notices of claim and notify the personal representative of that claim, which makes probate a long process. So not only do we have the complexity and cost of filing a petition, waiting for the appointment, still the process of marshaling the assets, we have to wait a long time, and there's always the possibility of a will contest, which makes things even worse. And finally, the personal representative, their job is to distribute the assets to the right people. So that could be either residuary devisees, maybe the specific devisees, but in either case, we want assets to go to the right people. So what does a will not do? So a will doesn't avoid probate. So one of the main challenges with a will is that it has to go through probate to be valid. So people are often surprised. Oh, I thought my brother had a will. That meant that everything was streamlined and we know exactly what they want. And to some extent, that's true. We do know what they want, but we need the court to actually carry it out. And the probate process is an expensive process. So filing fees are usually around $400. Publication in the newspaper is another $400. Attorney's fees range anywhere on the low end from $2,000 up to about $10,000 for probably what I would consider average probates. And that's primarily because there might be an objection, there might be the need to deal with taxes, to deal with actually helping with marshaling assets and resolving issues, making distributions. So it is an expensive ordeal. And contested estates, like I'd mentioned before, when somebody files an objection, attorney's fees easily on each side of that objection can exceed $20,000. And that's probably on the low end. And there's also the opportunity cost. So we're not able to take the assets of that estate and invest them even in a broad index fund where somebody might expect a historic return rate of about 8%. Rather than getting that 8%, we're hemorrhaging money through professional fees and the other cost attendant to a probate. And we think about that risk of a will contest. So there's always a possibility that somebody comes back and contests a trust, and that's the other major option in terms of an estate plan. But we find that that's not often the case, and part of the reason is when somebody files a will, the first notice that comes from the court is essentially a notice that says if you object, you have 30 days to file, or else you won't be able to contest this in the future. So the first thing that they see in the case of a probate is you better file your objection really quick. Will contests, as I mentioned, are extremely expensive. They take a really long time. I have a will contest right now where we're going on year 3 or 4, and it's terrible. And it's not really anyone's fault in particular. The courts are overworked. The support staff at the court are overworked. There are tons of cases in the probate court where these petitions are filed handle much more than just probating an estate. We see the court handling divorce cases, guardianship cases, change of names, and trust litigation. So all these cases are going through the divorce court, and it simply means there's just not enough time for these cases to be adjudicated in a speed that most people would want to see. So a will doesn't manage those assets of the estate long term. So at the very most, or the longest that we can hold assets, besides what we would call a testamentary trust, which I'm not really going to get into here, but suffice to say a trust created under a will, which has its own issues. For a general or an ordinary will, the longest that we can manage the assets would occur if somebody had a minor child, and we could leave the money to a particular custodian under the Uniform Transfer to Minors Act, and essentially we could leave those assets to somebody to manage the property for those kids until they turn 21. It leaves the kids vulnerable because we can't include a spendthrift protection, so we can't protect them from creditors, we can't protect them from themselves. Basically, everything gets distributed. We often lose tax efficiency, and that's primarily for estate taxes. So married couples lose their estate tax exemption when the first spouse passes away, and we lose creditor protection. We don't protect the estate from potential claims by mass health. We don't protect it from claims from your kids' creditors, and that could be a creditor like a divorcing spouse. So if your kids are going through a divorce, we lose an opportunity to protect their inheritance from those possible creditors. So let's get right into the tips. So tip number one, choosing your personal representative wisely. And this is really critical. And when I go through this question with my clients, I'm often talking about personality qualities. I'm talking about their profession, and not in the way that you'd expect. So when I ask what does the person that they're nominating do, I'm looking for potential conflicts of interest. So if somebody is in the business of selling securities, or they're a financial professional, there might be some temptation to sell an asset to the estate that really wouldn't be appropriate. I've seen great personal representatives from every walk of life. It's more about the personality and the mentality of the person than their chosen profession. And so what are the personality qualities that we want to look for? We want to look for somebody that is trustworthy, of course, but communicative. We want somebody that's going to talk to the family member and make them feel comfortable about what's going on. We want somebody that's conciliatory, or somebody that's looking for an agreement between the parties. It's really pretty difficult to work with a personal representative, especially if you're working on behalf of a devisee, talking to the personal representative, if they take the position that, well, this is their role, this is their estate, they get to do it, and too bad. We think about the relationship that they have with the devisees. So if there's some animosity between family members, we want to think about that before we appoint one of them in a position of control, but also a fiduciary position where that person owes a duty to the devisees. And we also think about the possibility of a co-personal representative. So that's somebody that would, or a group of people that would work together as personal representatives, where they could spread out the load. There would be two decision makers. Sometimes that can be helpful, especially if there's a case where there are two devisees. And so it's often advisable to name both of them so that there's transparency. They can both work on the estate, and that sometimes would work well, but it all depends on their personality and who's involved. Tip number two, proceed with caution if using an online do-it-yourself will. And I know this sounds self-serving, use an attorney because I am one and I get to bill people for creating wills, but that's not really the point. This is a legitimate issue that I'm actually dealing with right now. I have a case in the probate court where I've offered a will for probate, and the judge initially rejected it and essentially set the case for a trial. And the issue was the person that drafted it using one of the online services. I'm not sure if it was LegalZoom or some other service, but essentially it said, "My name is Jane Doe. I have no children." And then in the next paragraph it says, "I leave all my assets to my son." those two statements are inconsistent. You can't have no children and you leave everything to your son. And the interesting thing about it was that the person that signed this will apparently told the family members, well, good luck with my will after I pass away. I drafted it myself. So they saw this coming and they decided that it was fine just to leave this mess. And we're going on about 6 months that we've been in the process of trying to get this will probated. It looks like we have an off-ramp, so to speak. We're going to be able to fix it, but certainly it's cost quite a bit of money and time that we could have avoided had the will been drafted properly. Also, if you do draft your own will, we want to make sure that the signing formalities are followed. So you remember I said that it should be notarized and that it should be witnessed by 2 disinterested witnesses. That's critical. Without those witnesses, and preferably having a self-proving affidavit, which we won't get into, but suffice to say it saves time and money if there ever is a will contest. Respecting those is the difference between a will being admitted or denied from probate. And so, as you can tell, the deficiencies that might come from drafting your own will, they result in a large delay and expense to the estate that's really just not necessary. Tip number 3, don't store your will in a safe deposit box. I've had this happen before, and it's a pain in the neck. And all these things, they might be annoying to me, but that really misses the point, because my job is to simply help people with where their will is at. If it's a challenging situation, that's my job. The problem is my clients, the people that are actually trying to probate this will, they're the people, or they're the person that deals with this issue. And so if a will is stored in a safe deposit box, you have to make sure that the person who is going to be the personal representative can get into the safe deposit box. So if they don't have a key, if they're not on the signature card, they're not getting in, and we'll have to go to court and we'll have to get what's called a special personal representative appointment, and that will allow them to do a will search in a safe deposit box. So the personal representative should, if you're going to store a will in a safe deposit box, which I recommend against, you want to make sure that that personal representative has access, not only having a key, but that they're on the signature card so that the bank will allow them into the vault. You should have digital copies with your attorney, and I would recommend having the digital copy with your personal representative as well. And that would allow them to say, we've done a diligent search, we can't find the original, we're going to probate this copy in a formal probate. It's not ideal, but it's better than having to do a will search. And so what we already talked about, what happens if the will's trapped. You have to get a special personal representative, get the will, and then file a formal petition, or I think it has to be a formal petition if I'm not mistaken, to actually probate the will once you've found it. And we're talking about adding a significant amount of time and expense to actually do this. And probably the worst thing is when they can't find the will and there's no will in the safe deposit box, we're back to square one and we have to proceed with an intestate estate. My recommendation, keep the will either on your shelf in a binder. So when we prepare documents for our clients, we have a nice 3-ring binder, tab divided, all organized. Keep it right on your shelf. It's hard to miss. It says estate planning documents right on the spine. It's really hard to not find that if somebody's looking for your documents. Or if you're concerned about the possibility of a fire or them being destroyed, in that case, I would recommend putting them in a fire safe in your house. So fire safes are easy to open. And perhaps the most important part of all this is tell your personal representatives, not just the one you think is going to serve, but also the backups. You should tell your personal representatives where the will can be found. And that can save a lot of headache for the PR as well. The tip number 4, establish a record in preparation for a will contest. So every will that I prepare, I think, if this was presented in an open court, what would it look like? What's the likely outcome, and how would the judge find, or what facts would the judge find, and then what would the conclusion be? So simply, what does a court think if somebody contested this will? So I think about the circumstances around the will. How was I contacted by the client? Were there other people present? Are there financial incentives for somebody to be coerced or sign under duress? Does the person have capacity? And so what I try and do is I try and create a record of all those things and make it clear that the person's will is valid and I can be an excellent witness. You lose some of that if you prepare the will yourself, but it's still possible. recording a video explaining the reasoning for disinheriting somebody, writing a letter to explain some of your thought process. The letter itself can't be part of the will, but that extrinsic evidence could be helpful. If you have a dementia diagnosis, that's probably something you need an attorney to help you with. It's still possible to sign a will even if you're diagnosed with a dementia illness. It's a little harder. We have to think about what elements of testamentary capacity are there and when they're there. But ultimately what it boils down to is make sure that when a court is reviewing this in the future, we have the facts to draw a conclusion. So if that means recording a video, recording some audio, having witnesses that you're very close to but not taking under the will, and that's another thing. The witnesses have to be disinterested. So you can't have family members that are taking under the will witness the will, and because that could actually invalidate the will itself. In tip number 5, you probably saw this coming, consider adding a trust to your estate plan. And the reason we say that is the trust has a lot of benefits that a will simply can't match. First, we avoid probate. We have confidentiality, so it's not public record. One thing I didn't mention is that a will gets filed with the probate court. Anyone can go see it. So if you've disinherited somebody, if you don't want them to know what's in your estate, having a trust can be a really important tool to actually avoid some of those pitfalls. Tax efficiency. We'll talk about estate taxes in a couple minutes, but huge benefit to a trust by having this tax efficiency. We have creditor protection for both yourself potentially and also for your kids. So if your kids are going through a divorce with the proper language, we can protect that inheritance from the potential ex-spouse that your kids might have. And we also can protect minors, people with special needs, and then the creditor protection we talked about, and we'll go over in a little bit more detail in a moment. So what is a trust? A trust is simply a vehicle for transferring assets, and there's 3 jobs. We have a grantor, that's the person that creates the trust, establishes the rules, and in the case of a revocable trust, they're reserving the right to make changes to the trust. We have a trustee, that's the person that manages the trust property, and so they make investment decisions, and they can also be empowered to make decisions about distributing assets to the beneficiaries. And the beneficiaries that would be the last role, and they receive the economic benefit of the assets of the trust. So the grantor establishes this trust, the trustee manages the trust property for the benefit of the beneficiaries. And there are various types of trusts. The 2 that are kind of easiest to explain right now, or not, just the 2 to know about, are revocable trusts and irrevocable trusts. And they're similar. They have the same structure. The biggest difference is a revocable trust, just like it sounds, can be revoked, which means that the grantor, that person that creates the trust, they reserve the right to make changes. So we use revocable trust to avoid probate, maintain confidentiality, maintain tax efficiency, protect beneficiaries. We do special needs planning. And then we also use irrevocable trusts, which are trusts that can't be changed, primarily for creditor protection. So one of the big reasons that I create irrevocable trusts for clients would be to protect assets from potential mass health claims, which is the Massachusetts version of Medicaid. We also use it for tax efficiency, so taking assets out of the estate so that they're not taxed. And then also some forms of special needs planning would be appropriate with an irrevocable trust. And certainly special needs trusts that start as revocable can become irrevocable when the grantor passes away. So avoiding probate. We already talked about some of the downsides. We save time and expense. So in my experience, saves about 12 months and many thousands of dollars in expenses. We minimize the likelihood of a will contest. So you might remember I talked about the first notice that everyone's going to receive in the case of a will is if you object, you have 30 days to file your objection. There's also the ease of process and administration. The reason we think about this is it just takes a lot less time and it makes it easier for everyone involved. Confidentiality, we already talked about this a little bit, but the idea is the trust is not a public-facing document. It doesn't get filed in court unless there is some sort of legal challenge. At most, what people will know about it based on the fact that the registry of deeds might include the name of the trustees. They might know that a person is a trustee, who the backup trustees are, but generally, they won't know anything about the assets that are in the trust besides what's of public record. And it's not just what's in the will, it's also your family's responses to your family's response to the will in the form of an objection. So your family might start writing out publicly facing affidavits talking about dementia, undue influence, duress, medical issues, infighting between family members. For lack of a better term, they might file all your dirty laundry in the probate court, which a lot of people just don't want to deal with. We also think about tax efficiency. So in the case of a married couple, we can use both spouses exemption. So as you probably know, there's multiple different types of taxes. So we often think about income tax, sales tax, property tax, capital gains tax, and the ones that we're worried about primarily with an estate planning, from an estate planning perspective, are estate taxes, capital gains taxes, and then a little bit for income taxes, especially with qualified taxed or tax qualified retirement accounts. But this is a long way of saying we can save up to about $185,000 in Massachusetts estate taxes by using exemption planning, but for married couples, which can, that's $185,000. That's a lot of money to save for most of my clients. And then we also avoid probate, and we get a step up in basis. So when somebody passes away, the new basis for calculating capital gains, which if that's not something that you quite understand, I'm sure we're going to cover that in another webinar at some point, but we essentially get better tax treatment compared to gifting assets during your lifetime. Because a lot of my clients will say, well, can't I just give my stuff away to my kids? Wouldn't that do the same thing by just doing it during my lifetime rather than waiting until I pass? And this is where the trust becomes powerful. We can keep the asset in your estate, but also avoid probate and make that transfer really easy. So protecting beneficiaries, we've already talked about minor beneficiaries. So we want to make the money available to your kids while they're under the age of 18. But we also are concerned about kids that are 19 because in my experience, I've actually never had a parent want to leave assets to their kids at age 18 without any restrictions. And for good reason. All of us have been 18 years old. We know what it's like. And parents like to stagger distribution so that principal would be distributed at 25, 30, 35, with the money available for things like college, going to school, a wedding, maybe their first home. So the money can be available. The trustee can use it for the kids, but the kids can't use it and go buy an expensive car, buy a boat, lose it in a divorce. We get some protection in that way. Special needs planning, we're protecting beneficiaries with special needs from being disqualified from public benefits, and also protecting them from being swindled out of their money, or if that person simply can't legally manage assets based on their capacity, we have somebody in place that's able to take care of their estate. And then we also have creditor protection. We talked about this before with divorces and mass health liens, but that's a key part of the trust. It offers protection not just for you, but for your ultimate beneficiaries to make sure that they're receiving their inheritance without it being siphoned off. So that's the end of our webinar today. I just want to tell you a little bit about my firm. We offer a free consultation, so I'm happy to look at documents you might already have, or if you haven't started this process of actually creating an estate plan, I would love to help you do it. So we meet, usually takes about 45 minutes to an hour. We make it really easy. So all you have to do is click the sign up button that's on this page, or visit our website, cody-law.com, and you'll be able to schedule an appointment. Once you schedule the appointment, you'll receive an electronic questionnaire. It's really simple, it takes about 10 minutes to fill out, and it's basic stuff. What's your name? What's your spouse's name? What are your kids' name? What are your goals? So it asks you a lot of yes or no questions. And then it asks you a little bit about your assets so that we can understand what type of estate planning vehicle might be the best option for you. But I would encourage everyone to at least set up a consultation so you can understand your options. I have clients that decide to go with a will. their situation is such that it doesn't make sense to spend the time and money on a trust. But I also have clients that are surprised when they say, "Oh, I'm simple. I just want to set up a will," and then they say, "You know what? The added benefits of having a trust, the protection, the easiness with which a trust can be probated or administered, I should say, that all surprises them, and they decide to go with a trust." So I would encourage everyone to sign up for a consultation, and we'll be able to give you options in a no pressure environment, talk through everything, answer any questions you have, and then ultimately most of the people that I meet with decide to sign some documents. So I want to thank you again for watching the webinar. I think this is a really important topic, and if you do have any questions, feel free to contact us. But I, again, encourage you to sign up for a consultation so that I can meet you and give you some options. Thanks, and I'll talk to you soon.